using slang, intimidating word, my lord. He talked with me, my lord, making personal comments against lawyers community. So I decided to withdraw my wakalat from this court. Your lordship may kindly observe it.
You'll have to issue notice to
Well,
him.
then I told him yesterday over the phone to take back the file, my lord, and I will issue a notice. Kindly observe that, my lord. Item 25.
Learned Counsel Mr. P.J. Sukia has submitted that he will withdraw his wakalatnama from his client and he may issue notice.
My lord.
Okay, please
The
the
ground may be, my lord, mentioned, my lord.
client, i.e. Sanjeev Gogoi, as his client has
Slang, intimidating words, my lord.
you verbally abused him using intimidating words. Okay.
Slang words, my lord.
Verbally abused. Otherwise, he won't be defended also. Uh, it is also submitted that he will issue notice to his client. He will inform his
In
client.
fact, I inform
He will
him.
intimate his client. He'll through notice
My lord.
intimate his client. List this matter after vacation. List this matter after vacation.
Deeply observed.
May I please, your lordship?
Yes, yes.
My lord, MSc appeal matter has been filed on 28/11, my lord.
Mm.
May I brave for listing this matter after vacation, my lord?
Yes, yes. When do you want?
My lord, on 9, my lord, 9.
Okay, on time.
Yes.
My lord, with regard to item number 13, my lord,
Hmm.
my lord, the engaged counsel made it an accident, my lord, he fractured his leg. It may come after 2 weeks, my lord. Item number 13,
The English council met with an accident.
lordship.
Okay, learned council, Mr.
VK Borwa, my lord.
V.K. Borwa has met with an accident.
No, I'm VK Borwa. My senior name is not reflected in
Okay,
the
okay. Okay, learned counsel, Mr. V.K. Borwa has submitted that his senior,
Mr. KK Day, my lord.
Mr. K.K.
Day.
Day. That is senior learned counsel, Mr. K.K. Day. Is he senior?
Lordship.
That learned senior counsel, Mr. K.K. Day?
Not senior, my lord.
Okay, okay.
My senior, my lord.
That is senior, learned counsel, Mr. K.K. Day has met with an accident. List the matter.
After 2 weeks.
After 2 weeks. Okay.
I've taken consent from the government, my lord.
No, I will
Make a
other
best.
matter.
Consent has also been taken from the other side.
May I please, your lordship?
Mm.
I will to mention item number 22 for adjournment. I have taken consent of the other side. I am for the respondent.
Learned counsel, Mr.
S. Afridi.
S.
Afridi.
You are for the respondent.
Yes.
On behalf of learned counsel, Mr. Siladitya,
Yes.
representing the respondent, with the consent of the other side, has prayed for adjournment. List the matter after
Vacation.
after vacation,
Lovely.
winter vacation.
Item number 1 was on. This actually show moto, but it is referred content. Your lordship, can issue notice, my lord.
I'll issue notice.
My lord.
Okay. Learned senior counsel, Mr. T.J. Motor is present. Notices to be issued to respondent.
Only one respondent, yes, my lord.
Okay. Returnable on after vacation.
My lord.
Returnable after winter vacation. List accordingly.
Let it be after Bihu vacation, my lord.
Okay, okay, after Bihu holidays.
Item 2.
Returnable after March Bihu holidays.
In between only 5 days.
Okay.
In between Bihu and New Year's,
Yes,
my lord,
only 5 days. Very less working days.
My lord.
No, please, Your Lordship, this is a transfer petition of title suit matrimonial from District Judge Sibsagar to Principal Judge Family Court, Katha.
My God. Today's journey.
Yes.
Why? Will issue notice.
And we are pressing for stay also, Your Lordship.
No. Qatar will not stay.
It's too
Pending at which stage?
too far for the wife.
I know. Pending at which stage?
Pending at appearance and WS.
No, will not stay. Appearance and WS. Issues are not even framed.
But Your Lordship, this is too far, and she has no one to escort also with her. We took her from around 6
You see,
people
I'll
of-
give you one date. I'll bring it on record that interim stay will be considered on returnable date. Huh? Learned Counsel Miss
M. Acharya.
M. Asaria is present on behalf of the petitioner stating that the petitioner resides in Kachar
Kachar.
and this case is pending in the court of the district judge, Sibsagar,
Sibsagar.
who sub the petitioner. This is a divorce case.
Yes, Your Lordship.
How many cases you have between amongst you?
Your Lordship.
Between you, how many cases do you have?
There are 2 or 3 cases
Which the cases are pending in which court?
in district judge Sibsagar only.
Issue notice to the respondent returnable after Bihu vacations or Puja vacation, winter vacation. After returnable after winter vacation. Meanwhile, call for the scanned copies of the trial court records. The prayer for interim stay may be considered on the returnable day.
Acknowledged.
I can read. Transfer
Yes, my lord.
from which place?
Yes, my lord. My lord, this is Lokipur Kachar, my lord.
From?
He has filed, my lord, 2 cases, my lord.
Hmm.
Lordship, kindly have a look, page.
From Lakhimpur Kasar to?
Yes, my lord.
From Lakhimpur Kasar to which place?
Kachar, my lord, Lokipur Kachar, my lord.
From Lakhimpur to Kasar.
My lord, I am praying, my lord, any place, independent place, my lord. And another case, Lordship, kindly have a look, page, my lord, 41. She has filed, my lord, herself, my lord, 2 place, my lord. Now she has filed another case, my lord, page 41.
Hmm.
This is family court Kachar, my lord.
Hmm.
Headquarters Silchar, my lord.
Hmm.
An earlier case she filed, my lord, page 13, my lord. It
Hmm.
is filed, my lord, subdivisional area, my lord. This is in the court of subdivisional judicial magistrate, Lokipur, my lord,
Hmm.
Kachar.
That
And
is in the same district.
same district, my
Hmm.
lord. But 2 place, my lord, in between 30 kilometers, like that,
Hmm.
my lord, distance is
Where
there.
is the house of the woman?
My lord, petitioners, my lord. He is Ratabali, my lord. The
Ratabari.
Koringanj district, my lord, but Koringanj from Koringanj.
He is the defendant.
Defendant, my lord, husband, my lord. So, my lord, my prayer is that, my
Can
lord,
be transferred to his case, but not now. See, he is a man.
I
I
understand.
will issue notice and will not give you stay now.
My lord, kindly,
On returnable day.
well, otherwise, my matter may be infractuous, my lord. Kindly, lordship, kindly, she herself, my lord, filed 2 cases in 2 places, my lord. One, my
How
lord,
can matter be infractuous? This is pending at the end of the.
no, my lord,
proceeding.
appearance, my lord,
How can it?
my lord,
How can
written
anything
statement
be
is,
infractuous?
written statement is not filed.
I'll bring it on record. We will, what we will do, we will, after getting the record, we will,
Lordship,
see, at the first instance, you see, there are so many judgments debarring immediate stay, no coercive action. I'll bring it on record, you see. I'll bring it on record.
only, my lord,
That on the next day, we will consider, on returnable day, we will consider.
my lord, his prayer is, my
He's a
lord,
man after all.
yes, my lord, his prayer
It's
is,
not very difficult for him to travel. Do they have children?
no, my lord, she is, my lord, in her place, my lord, threatening, my lord. Therefore, the prima facie, my lord, she herself filed, my lord, 2 cases in 2 places.
He is threatening.
Yes, my lord. My lord. So therefore, my lord, even otherwise, my lord, here is, my lord,
Okay, let me see where she's threatening.
my lord, I have stated, my lord, in my petition, my lord.
In your petition, you can state anything.
Yes, my lord. Only, my lord,
Where,
prima facie
let's
case,
go back to the original
my lord,
case.
prima facie case is that, my lord. He herself filed 2 cases in 2 places, my lord. One is, my lord, Lokipur, another Silchar, my lord, proper Silchar, my lord. Therefore, my lord, safely, my lord, for the time, and my lord, my prayer is that, my lord, at my cost, my lord, any independent place, my lord.
You see,
Apart from, my lord, the hard place, Lokipur, my lord. Even that may be, my lord, come to the, my lord, family court, Silchar, my lord. Also, my lord, I have no problem, my lord.
she's a resident of which place? Lokipur.
Lokipur, my lord.
And your client is a resident of?
Ratabadi, Koringanj, my lord. And she herself, my lord, filed case, another case in Silchar, my lord. So at prima facie, my lord, that she would not have also objection, my lord, to transfer the case to Silchar, my lord. It would be convenient for her also, my lord. Or another case is.
But from Rathabadi, it is very difficult to travel to Silchar. I know the roads.
Yeah, yes, my lord, I am from Rathabadi, my lord.
Hmm.
So prima facie, my lord, at this stage, my lord, maybe paid, my lord. And my lord,
Which paragraph, which paragraph? That she has threatened her brothers, maybe, not she. How can she
Yes, ma'am.
threaten?
my lord, paragraph 6, my lord, after my lord praying for resolution.
No? You have not written anything about being
My lord,
threatened.
after some time, my lord, maybe taken action. After few minutes. Lord.
Revision, it is the order dated lordship 34 to 24 pass in miss appeal number lordship by the district judge lordship. Here, my lord, similar matters has been remanded back after issuing notice lordship, similar because these are the similar cases filed by the railway lordship. May I, today, my lord, I pray for a notice with justice service lordship. There's
No,
similar matter.
keep it, because I am issuing only notice, you
No.
need this.
We want a stay of that order lordship.
Okay.
Other matters are remanded back, lordship. Here, lordship, notice has to first, after appearance there, it has been remanded. Similar matters.
What is the judgment about?
The eviction, lordship, under the state officer public premises eviction act, lordship, we have issued notice. They have filed appeal against that order. Our notices were set aside. And honorable, the coordinate bench has allowed the appeal for redeciding the matter, lordship.
Same matter?
Same matters.
Out
Same-
of the same course of action?
Same cause of action, same notices were.
Okay.
Hmm.
You are for the railways?
Yes.
Okay. This is a judgment order, final order, or appeal against that issue? What is this? That district, against the district judge's order?
Yes, yeah.
Let me see the district judge's order.
Lordship, in page number 88, lordship. Start from page 88. We issued notice under section 4 of public
Public
premise
premises act.
eviction.
And then what happened thereafter?
Thereafter, lordship, district judge allowed the set aside the notices. We came before this honorable court, and this honorable court interfered with the order and remanded back the matter to decide afresh.
Miss appeal, but this is Miss appeal 26.
There are several notices, this was 26, these are same eviction notice we have. There are several other filed lordship. There, next case also, it was in Miss case 28, they have filed individual appeals. lordship.
Miss appeal 26 in
Look.
Miss eviction number EOMLG 5/2021.
Yes,
Same notice.
notices are same, and just same plot of land. Under the same dark railway dark.
No, no, no. This is different. This order has been passed in another case. They may not have the same cause of action. You see, some people may occupy public premises, some people may not occupy public premises.
Lordship, these are, they are possessing the land where we have given the individual notices, same plot of eviction document.
EOMLG 5914, but this is EOMLG 05.
05,
And this is 2017 and this is 2021.
21, there are others are also there. Lordship. There,
The judgment you have given is 2021 and but The appeal, present appeal is 2017.
Lordship, I'm giving Lordship. 17 or control. 17. There are 17. 17 or control. It to 21. G control. 50. No, these are. These are the same railway plus notices are different. That's why Lordship.
But earlier, no stay order was granted in this case. In this case, no stay order was granted.
No, we
Only state.
only notice Lordship. My friend says only notice.
Only notice.
Only
yes.
notice.
Only.
No,
Issue notice, yes.
That's the service.
Issue notice, no problem. Learned Counsel,
Lordship,
your name?
SS Road,
Learned Counsel, Mr. S.S. Roy is present for the, you are CGC.
CGC.
Learned CGC, Mr. S.S. Roy is present for the appellant and appellant, full stop, issue notice to the respondent or respondents.
Respondent. Sing one.
Appellant to take steps to issue notice to the respondent, one respondent, okay?
Yes,
Returnable after winter vacation,
full Lordship.
okay. List on. It'll grade you. 19 January,
Lordship. That including Dusty Lordship.
or notice, dusty service is permitted.
Lordship.
Returnable after winter vacation, nala, returnable on 19 koi diya.
Item 5.
Here same Lordship.
Okay,
Here-
it will likhe diyo.
3 respondents, 4 respondents had.
Yeah, respondents, huh?
Item 6.
Obliged.
Mm.
Made pleasure lordship.
Mhm.
My lord, I filed a petition for amendment of the WS.
Mm.
So, my lord, in that petition, that petition was rejected
Mm.
by the court below, my lord,
Mm.
observing that there is lack of due diligence. Your lordship will turn to page 67.
Okay,
Page 67,
yes, please.
paragraph 26.
Yes,
So, my lord, but in the instant case, by amending the written statement, defendant cannot be allowed to resile from the earlier statement of admission made in favor of the plaintiffs, which if allowed would cause in prejudice to the plaintiffs, more so when there is lack of due diligence. So, my lord, challenging this, I filed this CRPIO. Then your lordship passed an order on 14/7/2025 in CRPIO.
Mm. Where is the order?
14/7/2025
Page?
in the CRPIO, my lord, in this order, in this
Okay,
case.
okay. In this case,
Yes,
okay. All right.
so your lordship by this order directed me to file an additional affidavit explaining the due diligence.
Mm.
What is the due diligence by the petitioner to file the amendment after the issue was framed? That is after trial is started. So, my lord, I filed this additional affidavit.
Okay,
Now your lordship will turn to page 77 of my additional affidavit,
page 27 means.
page number 77.
Mm.
Additional affidavit. Here in para 7, my lord,
Yes,
I elaborately tried to explain before your lordship
Yes.
that due diligence, my lord, how there is some delay. Not filing this, not filing the amendment petition before framing the issue or trial is started. That I have tried to explain, my lord. Your lordship would be pleased to see para 7. Para 7, my lord.
Yes, I'm reading.
Then now your lordship
Let
will
me
come.
read the para 7.
Yes,
Just a
ma'am.
moment. I'm reading the para 7.
Para
Just a
7.
moment.
And
Let me read it. Let
Hello.
me read it.
my lord,
Para 7. Let me read it.
my lord,
I'm reading it.
my lord.
I have halfway through.
Yes,
Just a moment.
Order 6, release 7, then to be provided. अच्छा
So the plaintiffs have been cross-examined,
not cross section.
not cross-examined, but they have given
Thing
evidence.
is this, only they file PWs. 2 PWs has been filed. madam.
Evidence they have.
Yes, I have
Okay,
received the
all
copy,
right.
madam.
All right.
But cross examination is not.
Right.
Yes, ma'am. Not all.
Learned counsel, heard learned counsel, Mr. M.A. Sheikh for the petitioners. Sri Rontu Nath and Sri Hongtu Nath, who alias Sontu Nath, who have filed this application under Article 227 of the Constitution of India for setting aside the order dated 7/4/2025 passed by the learned civil judge junior division number Morigaon in which J case number 154/2024 arising out of TS number 43/2022, whereby petition under order 6 rule 17 read with section 151 of the CPC was rejected. It is submitted by the petitioner that that a petition under order 6 rule 17 no
Yes.
was filed by the petitioners for amendment of the written statement, which was rejected. Full stop. It is submitted that if the petitioners who are not allowed to amend the written statement, comma, they will be highly prejudiced and the matter will be rendered infructuous. Full stop. When the petitioners have preferred this petition against the order of the learned civil judge junior division, comma, another order was passed by this court in CRP IO 251 of 2025, i.e. The instant case on 14/7/2025 to file an affidavit to explain due diligence on his part in filing the amended petition before the court. It is submitted that through the additional affidavit, the petitioner has tried to explain why there was a delay and why the petition under order 6 rule 17 was filed after filing a written statement. After filing a written statement or before framing issues?
After starting the trial.
After commencement of trial, no? Filing a written statement or commencement of trial, it appears that there is there are sufficient grounds to stay the proceedings of Mijay case number.
No,
No,
but
of
this
that-
title shoot number 43 of 2020,
TS 43 of 2020.
24.
2024, at least till the next date of listing.
Munship number 1 Morigaon.
It is submitted that, I have also considered the submission that
Munship number 1 Morigaon, my lord, now it is written as Civil Judge Senior Division.
it is also submitted that witnesses are yet to be cross-examined. And evidence in chief to affidavit has been submitted, full stop. It cannot be considered that this case is it can be considered null, full stop at rejection. It is further submitted that this case is still at the initial stage of trial, full stop, considering all aspects, the proceedings of TS number
43 of 2024.
pending in the court of the civil judge junior divisions,
My lord, Civil Judge Senior Junior Division number 2.
civil judge junior division number 2 Morigaon till the next date of listing. Meanwhile, also the scan copy of the trial court records list after data the detail.
Abla Jilas.
Item 7.
Lordship, matter will be taken after some time. Mr. Yes, this is on lag.
All right, sir.
Deeply of the Lordship.
My lord, the petitioner seeking another opportunity to file WS, my lord. My lord, the impugn order may be seen at page 30.
As per the order.
No, my lord, I filed an application that the petitioner is suffering from some illness. So another date may be fixed for filing written statement, and that was the date of 90 days, my lord, expiring 90 days. So, my lord, I'm praying before this court, my lord, 90 days period can be extended as the Supreme Court has said, in some circumstances, my lord.
Have you given any documents relating to your medical condition?
Actually, that was the deficiency, my lord. I could not furnish at that moment the medical certificate, but I have annexed the certificate here, my lord. My lord, kindly see page 30 to the vernacular, my lord. My lord, everything is ready, my lord. My written statement is ready. Just, my lord, I want to file on the next date, my
Give
lord.
me your order, Supreme Court judgment.
Lordship. Dada. I have flagged my mind.
Your name?
M.
I'll dispose it off. I'll
Lordship,
them to.
I'm highly honest.
Your name?
M. Ali, my lord.
Hard learned counsel, Mr. M. Ali for the petitioner. Babul Ali.
Babulal.
Babulal Ali.
Babulal Ali alias Babulal Bora.
Babulal Ali alias Babulal Bora, who has filed his application under section 115 of the CPC, read with article 227 of the Constitution of India. CRI to capital D, challenging the order dated 13/10/2025 passed by the learned civil judge senior division Kamrup Amingaon in TS number 43 of 2025, whereby the petition filed by the petitioner as dependent number 1 seeking time to file WS was rejected. Full stop. It is submitted that at the time of filing the petition, the petitioner failed to submit medical documents, and thus his petition was rejected. as the period of, as the statutory period of 90 days had elapsed by then, full stop. Now the petitioner has submitted a certificate by the SDM and HO of North Guwahati BPH, Kamrup, Assam, which reflects that the petitioner was suffering from hypertension from 13/10 to 2025. 13/10.
13/10 to 14/10, 2 days.
13/10/2025 to 14/10/2025. Course of the petitioner has also relied on the decision of the Supreme Court in Kailash versus Nangku and others, wherein it has been held that
Ballot page 18. Where Roman 4 and 5 of para 46.
okay. Reported in, he's an he,
Reported in 2005,
2000
4 HCC 480.
2005 brackets of Victor Bhaiva, 2005, 4 SCC 480. এইটো হেৰি মেইন পেৰাগ্ৰাফটো হ'ল 46 হা 46ত তুমি এই পেজটো টেক কৰা আছে ৰোমান 1-ৰ পৰা ৰোমান 5 লৈকে আছে বাকিখিনি 1-ৰ পৰা 3 লৈকে নালাগে ডট ডট এটা দি দিবা তাৰপিছত 4 টো দি দিবা 5 টো চাওঁ দিবা Okay.
Roman 5 says, depending upon facts and circumstances, sometimes court may impose cost also.
Hmm, 5 to video. 4 or 5. Reverting back to this case, it is held that an opportunity may be accorded to the petitioner to file his WS, so he was indeed suffering from hypertension, and a medical report marked as annexure
1.
1 reflects that the petitioner has recovered.
Sorry, my
by
lord,
now.
annexure 4. I'm sorry.
Okay, annexure 4 reflects that the petitioner has recovered by now. So it is submitted that the written statement is ready and within short time the petitioner and within minimum time required the petitioner will submit his written statement if his petition is allowed. Full stop. I have also taken a pragmatic view and I have considered the medical certificate. Full stop. in the light of the decision of the Honorable Supreme Court in Kailash Supra, this petition is disposed of without issuing. This petition is allowed. The order dated 13/10,
My lord, yes, my lord, 1310,
13/10/2025
lordship.
is hereby set aside and the petitioner is directed to immediately appear before the learned trial court and submit his written statement.
My lord, next date is 5/1/26.
Submit his written statement on the next date fixed.
Highly obliged.
Petition is allowed with cost of rupees 5,500
500.
to be paid to the respondent.
Right.
Result from the above observation, this application stands disposed of.
I'm obliged.
This petition, this CRP stands disposed of.
Obliged.
Mm.
May it please your lordship.
Mm.
Lordship, this CRPIO has been filed for setting aside the orders dated 18th of July 2025 as well as 10th of October 2025
Mm.
passed by the Court of Member MACT 3 Kamrup Metro Lordship.
Mm.
Lordship, on 18th of July 2025, Lordship, the matter was fixed for evidence. The counsel for the claimant, that is a petitioner in this matter, had sought for some time to file some evidence. Instead of giving some time, Lordship, the matter was no opportunity was given, as well as and the matter was fixed for hearing of DW1 on the next date, Lordship. Lordship, some opportunity may be given to file the evidence as well as for hearing, Lordship. If no opportunity of hearing is given to the claimant, Lordship, then the case wouldn't take in the proper manner, Lordship.
We'll stay at this moment.
Yes, Lordship,
We'll
saying
stay and then we'll issue notice.
yes, Lordship, saying orders dated 18th of July as well as 10th of October, Lordship, 2025, Lordship.
Arboro?
Arboro, Lordship.
Learned Counsel Ms. Arboro is present for the petitioner Lal Babu Shah, who is aggrieved by the impugned orders dated 18/7/2025 and 10/10/2025 passed in MSC case number 463/2021. It is submitted that by the impugned orders, the petitioner was not allowed an opportunity to file
Evidence, Lordship.
to
File evidence and no hearing opportunity was also given, Lordship.
to file evidence. The petitioner was also not allowed any hearing opportunity. It is submitted that the petitioner will be highly prejudiced if he is not allowed to place his case before the court. The orders, impugned orders are marked as annexure.
Page number 29 and 30, Lordship. Annexure 3, Annexure B series, Lordship.
Annexure B series, 18/7/25 and
Page number 29, 18/7/2025 and 10/10/2025, Lordship. Page number 29 and 30, Lordship.
Insurance company. Your
Other side
insurance
is Lordship. Insurance company, Lordship, not insurance company, Lordship. Other side is it's a private party, Lordship, driver and some police headquarters. Respondents 1 and 2, Lordship.
Okay. Why you are added as DW?
Lordship, I was added as PW1, Lordship, not DW. DW is the other party, Lordship.
Okay, it has been fixed for DW.
Yes, Lordship. Without giving an
You are the claimant.
Yes, Lordship. Claimant in the embassy. Yes, Lordship.
The petitioner is the claimant, and it appears that he may be prejudiced if he is not allowed to adduce evidence. Thereby, the orders dated 18/7/2025 and 10/10/2025 is stayed till the next date of listing. Meanwhile, call for the scanned copies of the trial court records and issue notice to the respondents returnable on second February.
Deep Lordship.
May I please, Lordship? My lord, there is one school, B.R. Milan High School, Bukua Tepa. It is in the district of Porpeta Valley. My lord, since lordship may kindly see the order page 17. 17. To the headmaster in charge, B.R. Milan High School, Bhukuatepa. So this name was all along there. This is the letter of IS. And now lordship may kindly see page 18 onwards.
Okay.
B.R. Milan High School, Bhukuatepa. Kindly see now page 18, man. Here, these are the admit card.
This is for admission.
Yes, admission, my lord. B.R. Milan High School, Bhukuatepa, lordship has seen page 18. This is the admit card always been used. Mark sheet, lordship kindly see. B.R. Milan High School, Bhukuatepa, Rauli. 19. Then 20, lordship would see B.R. Milan High School, Bhukuatepa, Rauli. All along this name has been used, and the IS, after hearing the parties, passed the order that we have said that page 17, my lord. All of a sudden, IS, due to unknown reason, my lord, again passed an improved order. Earlier order was passed on 17/4/25, and later order 14/11/25, page 16, lordship kindly see. Page 16. Now, here it is written that kindly see page 16 bottom. Therefore, the headmaster in charge B.R. Milan High School is here Bhukuatepa is not there. Is requested to maintain the school address as recommended by the inquiry committee mentioned above with immediate effect. And in top, my lord, the headmaster in charge B.R. Milan High School. Now, lordship kindly see the certificate where the school is situated. Lordship may kindly see page 37. Page 37A. This is the certificate by circle officer. This is to certify that land measuring 2 bigha, 4/7 lesser covered by DAG number 356 of Mehdi Patna number 30 of village Bhukuatepa under Sorukhetri Moses stands in the name of B.R. Milan High School, and the said school is situated on the said plot of land. That means Bhukuatepa's village, the school is situated. Of all sides since earlier till today, but all of a sudden the IS, due to unknown reasons, my lord, he passed the order on 17th for the Bhukuatepa shall remain there, but here Bhukuatepa name is omitted, though the school is situated there. Then, my lord, we filed a title suit before the learned civil judge at Borpeta, along with a petition under section 82 CPC, there was some urgent relief, but that was returned because the notice was not served. But lordship is sometimes it may be provided. So we have now also challenged that order that the return of the suit by the learned civil judge was also not proper. However, we are not on that. Our only prayer is at present is that 17/4/2025, when the order was passed by IS, that name should be status quo ante as on 17/4/25 may kindly be kept in evidence, kept in force,
Which order?
That is page 17, my lord. Page 17 order. School is in our land, my lord. So there is no reason as to why the place's name shall not be, but my lord, see, this is, I don't know why the IS has moved, how people could make him menaced. So, though here clear the name is there to headmaster in charge.
You are asked to mention your name on the signboard.
A signboard, yes, signboard and address.
Where is the problem?
But
Please
Rauli
mention
would be
your name
there.
in the signboard.
My lord?
Where is the problem? You mention your name in the signboard.
Yes, mention it is written as B.R. Milan High School, Bhukuatepa, Post Office Rauli. It is written everywhere here. So, Bhukuatepa High School, sorry,
You are
B.R.
against which order?
My lord,
You are coming before this court against which order?
against this order, that is page 16, my lord.
Page 16.
16.
Okay.
17 should be there.
Okay,
Page 16 here, lordship would say,
16.
the B.R. Milan
high school, only high school, where it is stated, not stated. So it is vague order, it is motivated order, my lord. So the name should be written as B.R. Milan High School at Bhukuatapa, Post Office Rauli. But here it is written Bhukuatapa B.R. Milan High School, Post Office Rauli. Place of the high school is not written.
Yes.
Lordship, at this station, notice may be issued. Lordship will verify whether the facts stated is correct or not. Lordship, we would like to file an affidavit verifying the facts, Lordship. On the
But
next.
every document we have annexed. We have annexed all
To verify
documents.
the department, Lordship.
But the status entry was on 17th, but that may
They won't, I think they won't, what is, you are agreed by what?
agreed by this order, that is page
You've
16.
not gone through the order. Let me
But-
go through the order.
Page 16,
I'm
ma'am.
not at all aware about the order. Let me go through the order.
Yes.
I'll read it.
Yes. Just see the next page.
Just a moment. I'm reading it.
Yes. Now, Lordship has seen this B.R. Milan High School, Post Office Rauli. It is written now by the IS. But earlier it was Bhukuatapa, B.R. Milan High School, Bhukuatapa, Post Office Rauli. Now, my learned friend has said that she will file affidavit, but let me satisfy your Lordship. Page 18 kindly see it. Again, I'm doing then, I wanted to short my argument, but as my learned friend is saying, kindly see the since earlier the high school living certificate page 18, my lord. High school living certificate examination so and so. Kindly see the school's name B.R. Milan High School, Bhukuatapa, Rauli. Lordship has seen. Page 18. School's name.
Bhukuatapa Rauli, yes.
Yeah. Then Lordship kindly see page 19, my lord. Here name of the school kindly see. B.R. Milan High School, Bhukuatapa, Rauli. Lordship has seen. Page 19.
I'm checking.
Then kindly see page 20.
Yes, yes.
Name B.R. Milan High School, Bhukuatapa, Rauli. Everywhere, all these papers. Always B.R. Milan High School, Bhukuatapa, then page 21. These are mark sheet.
Asked to name
Name is-
signboard as?
B.R. Milan High School, Bhukuatapa, Post Office Rauli.
Where is the problem?
my lord?
Same, Rowley, Bhokwatapa Rowley.
No, no. Bhokwatapa, yeah, Bhokwatapa we won, but now Bhokwatapa is omitted,
Okay, post office.
where the school is situated.
Okay.
So we want that matter, nothing more. If they have anything, they are saying that since earlier it is absolutely false because we have annexed the documents on oath. How we can annex, if any false is found, then we are liable to be for.
What kind of stay order you are asking? I don't
I
understand.
only want that the order
Uh.
that lordship may kindly see. Page 16, that order I want to stay. Or status quo as on 17/4/25. Page 17. 16 I want to stay and 17 I want to remain till the matter is heard.
Lordship, it needs to be verified, Lordship, whether it's the same or not, Lordship. Lordship, sometime may be given, Lordship, like
Let us.
after
let-
Bihu,
let-
Lordship,
it is
right
not
after
required to
Bihu.
be stayed.
There's no urgency in this
Actually,
matter, Lordship.
No board examination, nothing of sort coming up.
The matter is not that matter. Actually, some persons,
I know. They have written that they are
they have some ulterior motive behind this. School may be also taken away. So our land is, we have donated the land. It is in our village, Bhokwatapa. So how that name, that is,
They will obtain instructions there. By the time they won't take away.
but some status quo as on 17/4, that may kindly
No,
mention.
no. They won't take away your security. This is the board. They are. You are for education department.
Education department, Lordship,
They
one
won't
to
take away
inform,
your-
Lordship.
Some relief, my lord, because it is since earlier it is used.
No, not now.
We have seen balance of convenience is in our favor. Kindly consider prima facie case is in our favor, balance of convenience and our
You are
law
not asking for injunction. You are asking for stay.
stay, but that is the injunction petition was there before the land is civil judge. That I have annexed, my lord, here. That I have annexed. Kindly see page 51. Page 51. That is the injunction petition.
But it was not allowed.
No, it is written on the ground that because the case has been filed without following the procedure as provided under section 81 of CPC.
But you are against the, not against that order.
Yes, I am also against that one.
No, no, not also where.
No, kindly see the prayer.
The impugn order dated 14 whereby this is only against the education board's order.
No, no, no. Kindly see page 13. Kindly see page 13. Why the impugn order dated 14/11/25 passed by Inspector Visu, Borpeta District Circle, Borpeta, changing the name as B.R. Milan High School, Post Office Ravli, replacing the earlier name B.R. Milan High School, Bhokwatapa, Post Office Ravli. We want this. Shall not be set aside and coerced.
You
Then,
can ask for only one relief here.
no, that is thereafter, Lordship, kindly see.
No, no, no. You can ask for only one relief. You are
I
coming
know.
against one order and I'm not going to that Miss J case.
But Lordship, that one relief.
But we will not stay. Not stay. We'll pass an order, we'll issue notice and we'll ask her to obtain instructions. And on the next day, based on her instructions, we'll pass an order. If required, then we will stay. And I think it won't be required also.
My lord,
I don't think so. it
School
will
is
be
in our land, my lord. In the
It will
land of,
remain in your land. It will not go, school will not move from your land.
my lord, we are submitting. My lord, this is our Guwahati High Court at Guwahati. So if it is taken the Guwahati High Court at Itanagar, it cannot be so. So my lord, this is my reasonable prayer. And it is always being used by all boards.
So that post office, Howli is not.
There is no dispute. Post office Ravli, there is no dispute.
Then it is in Howli only. It is not-
Ravli.
Huh?
It is Ravli.
Yeah.
It is Ravli.
Ravli, okay.
B.R. Milan High School, Bhokwatapa, Post Office Ravli.
And now they are asking you, B.R. Milan High School,
Post office.
Bhokwatapa omitted, at post office Ravli,
Bhokwatapa is only.
omitted.
Now Post Office
No,
Ravli is
your
there.
example is not correct. The Guwahati and Itanagar example is not correct.
No,
It is Ravli only.
only an example. So, B.R. Milan High School, Bhokwatapa, that may be used until,
Obtain instructions.
Until
She'll obtain
Lordship,
instructions.
I'll obtain, Lordship.
but it is reasonable prayer. Mama.
First day, no. I don't find any reason in the prayer. That is why I'm not granting.
Because,
If I find reason, I'll definitely grant. I'm not finding no, I'm not finding any reason. Maybe after she obtains instructions, we may file it. For Hunkala Didiba. Learned Counsel, Mr. M.
Then interim prayer may be considered on the next day.
M. Mahmood is present for the petitioner. And Learned Counsel, Ms. Arbor is present
For respondents 1, 2, and 4, Lordship.
for respondent number.
Standing Counsel,
Education.
Secondary Education Department, Lordship.
Learned Counsel, Standing
Standing
Counsel.
Counsel, Secondary Education Department, Lordship.
Secondary Education Department, Ms. Arbor is present for the respondent number 1,
1, 2, and 4, Lordship.
2 and 4, full stop. Full stop, no, comma. For 3, okay. Comma, and has, okay, and has submitted that she may obtain instructions relating to the grievance of relating to the notification dated 17/11 and
Lord,
Order, that is not.
14/11,
order 14/11
2025.
Full stop. Learned Counsel, Mr. Your name? Your standing counsel?
Yes, my lord, for SSA, respondent number 3.
Learned Standing Counsel for SSA, Mr. B. Chaudhary.
Yes.
Is present for respondent number 3. List this matter on 5th January. And instructions to be obtained on 8th January. The prayer for interim or protection, interim relief may be considered on the after obtaining instructions. After receiving instructions.
On the next day.
On the next date, okay. After receiving instruction and on the next day.
May trigger also.
Mm.
Not, we have challenged an order whereby my lord amendment prayer was allowed. Basically, my lord, cases like this, that one Nokul Chandra Borua, he was an advocate, my lord. He died on 29/12/2017.
Mm.
Before his death, he executed a will
Mm.
in favor of the petitioner who filed the misprobate case, my lord. The petitioner, my lord, is not directly related, my lord. He is the nephew.
Mm.
And the respondents in the misprobate case are the wife and the sons and daughter of that Nokul Chandra Borua.
Mm.
The present petitioner is the second wife.
Mm.
So she is also contesting that case. Now, basically, that is a probate case, my lord, which this Ranjit Borua had filed for probate. And
Ranjit Borua is the nephew.
Ranjit Borua is the nephew, saying that the Nokul Chandra Borua had executed the will by putting thumb impression on 7/11/2017. My lord, he is an advocate,
Mm.
but he put thumb impression and executed the will. Now, how it was executed, it was not mentioned. Thereafter, my lord, we filed our written objection. Then several dates passed, my lord,
Mm.
in evidence days. If your lordship will kindly see page number 31, around they took 6 adjournments for filing evidence of PWs, and after that, my lord, evidence of PWs was finally closed.
Mm. Mm.
Then, after a very belated stage, that means when the trial has already started, they come up with this petition at page number 32 under Order 6, Rule 17,
Mm.
praying for amendment of the original probate petition.
Mm.
Now, what they want to incorporate is that how the thumb impression was affixed, that he was having neurological problems. So, my lord will kindly see at page number 34. This is the paragraph which they want to incorporate. That the writer of the will, as per instruction saying of the testator, my lord, page number 34,
Mm.
prepared the will, presented before him, and these are part of the evidence, my lord.
Mm.
Normally, my lord, the pleadings should contain that he executed the will. Now, how, the manner and mode, these are part of the evidence. But
Mm.
what they are now trying to do is that they want to incorporate all these things in the original petition, my lord.
Yes.
That too at a belated stage.
Pleadings has to be incorporated. Otherwise, how they will adduce
No,
evidence?
pleadings will be there.
Mm.
Pleadings will be there. But this part, now the thing is that my lord, regarding Order 6, Rule 17, it says that amendments should be normally allowed. But if trial has already started, then the party should do due diligence that why these things were not brought earlier. Now, their reason is that change of counsel. Only after they engaged the new set of councils, these councils came to know that these things were not there. Now they want to incorporate at a belated stage, my lord. And my lord, without even going into that, my lord, the lower court simply allowed this petition, my lord. Our contention is that it is nothing but lacuna. My lord will kindly see an advocate, my lord, who definitely has.
Maybe
knows
he
how-
was having neurological problems.
These things were not there in the original petition, my lord. Such vital things that he was having neurological
So
problems.
after additional evidence, you disputed this fact? Did you dispute this
No,
fact?
no, cross has not yet started.
So
Cross-examination
it
has
was not disputed.
No, we did not, no,
Hmm.
only when it comes to the stage of cross-examination, then we definitely would have disputed. But before that, they filed this petition saying that they want to incorporate in the original petition, my lord. And the court below, without even, my lord, examining.
Have you mentioned that this advocate will not use thumb impression in your plaint? This is a plaint or
No,
this
no.
is in a WS? Have you mentioned in your WS that the
We have,
advocate?
yes, we have denied everything, my lord. Each and every paragraph we have denied.
Hmm.
And regarding thumb impression and all, my lord, we have denied that. That our objection starts from, my lord, page number 23. These things were never before in their original petition, my lord. And what made the testator
Where, which paragraph? Page 23, the thumb impression of an advocate?
Thumb impression, generally we have denied each and everything, my lord,
No,
because
no, general denial will
because
not work.
no, because my lord, thing is that
No, no, no.
they-
Where? Show me, show me. General
Lord, in
denial,
the
you will
original-
deny
in
everything.
the original
See,
petition,
this is the main,
in the original petition, my
this
lord.
is the bone of
Yes,
contention.
no, in the original petition, they simply said that executed. Executed.
Mm.
If your lordship will kindly see page number 13, the original petition, my lord.
Okay. Have you seen the will?
No, will be not with us.
Okay.
At page number 15, para number 3,
Page 15.
para number 3.
Let us read the original plaint and then we will.
Para number 3.
Let us read the entire plaint.
Yes.
And then we will
Yes,
decide.
yes, it starts from page number 15 only.
Yes.
This is the vital
Hmm.
para, my lord, para number 3.
No, we'll read the entire.
Yes. That the testator
I'll read it. You sit down, I'll read it.
my lord.
Have you given the original?
My lord,
You have given the type copy.
type copy.
Original?
Original, my lord, we have not placed, my lord. It's a type copy.
Let us get the records.
My lord,
We will pass an order of stay.
my lord,
Okay.
matter is fixed on, my lord, 22 of January.
Well, before that, we'll get the scan copies only. Then we will see the
My lord.
petition and then we'll pass an
My
order.
lord, the paragraph here is that
Hmm.
third paragraph, my lord. It has been simply said that third paragraph, my lord, that shows that 15. Although the opposite
No,
part.
you should have given the original copy. It would have been easier.
Yes.
Then I wouldn't have called for the records. Not
Just,
the type
just for
copy.
reference, my lord, just for reference.
No
Al-
point, no.
Although the
No
opposite,
point.
my lord.
No point.
Right.
We'll need the original copy of the original, not type copy. Plenary Council, Mr. Ayaz is present for the petitioner. Issue notice to the respondent returnable on January 20 January agot dijo. Meanwhile, call for the scanned copies of the trial court records of Miss J case number. Miss case number, Miss J number, Miss case
16
number.
of 2000, Miss probate case,
Miss probate case number 16 of
2008.
2018.
It's
That is the Miss case, that is the where we'll get the original plaint.
my lord.
Okay, original petition.
Yes.
Okay. Miss case number 16 of 2000,
18.
18. Then the prayer issue notice to likhila na. The prayer for stay of the impugned order will be considered on the next date fixed. Okay.
On that is 9 of January.
It is 9 January.
Highly offense,
If the records won't come, then we can again insist for another date.
my lord.
I think any court, even if I am not there, 9th of moi nathaku, you want me to be there? Then I will have
Your
to take
lordship
up on.
witness, my lord.
Then we will have to take up on 19th. If you want me to be there, I want 9 January DDA.
Fine.
May I please?
Mm.
My lord, I have stated, my lord, at paragraph 3, my lord.
Mm. Paragraph 3
3, my lord.
of the plaint.
My lord, in my
of your
petition, my lord.
Please read paragraph 3.
My lord, paragraph that on 18/3/2025, the respondent wife filed one Miss DB Act case number so and so before the Court of Learned Subdivisional Magistrate so and so Kachar against the present petitioner has been praying for certain unacceptable relief against the petitioner under section so and so of the Domestic Violence Act 2025, seeking relief under section so and so of the said act. After receiving the notice of the said case, the petitioner tried to contest the case, but whenever he appears.
Okay. All right. Our learned counsel, Mr. M. Borguia, for the petitioner X, who has filed this application under section 24 of the CPC for with prayer for transfer of the Ms. DB Act case number 5/2025 from the Court of Learned SDJM M. Lokhipur to
Any independent neutral place, my lord.
to the district of Sri Bhumi or any other jurisdictional court of neutral place, as the petitioner has been threatened by the respondents, family members and henchmen. Henchmen also.
Yes.
Family members and henchmen. She's so powerful.
My lord, because my lord, I have what use my lord hooligans, my lord.
Full stop. It is submitted that another case has been filed by the petitioner.
My lord, this
By
is
the petitioner or by the respondent?
yes, well, FC within bracket civil case number 315/2025 before the
This is filed by the petitioner, no? Divorce.
no, my lord, wife, my lord.
Okay. By the respondent, which is pending in the court of the
Family court, Kachar Silchar.
family court, Kachar Silchar, and is registered as FC civil case number
315/2025, my lord.
315/2025.
For divorce, my lord.
Post of the with prayer for a decree of divorce. Full stop. Any other case?
No, my lord, no, my lord.
It is submitted that the petitioner is willing to contest with the case and the contest the present Ms. DB case number 5/2025, but he is unable to contest as he is apprehending threats from the respondents, family members and other antisocial elements. Full stop. It is submitted that another case was brought up by the respondent in the district which is pending in the court of the district Judge Silchar.
No, family court, Kachar Silchar, my lord.
Yeah, in the family court, Kachar. In the family court, Kachar, Silchar. Full stop. It appears that nobody will prejudice if in any one of the case, nobody will be prejudiced if the case is transferred. But at this stage, the case is Ms. DB case number 5/2025 is stayed till the next date of listing. Meanwhile, call for the scanned copies of the records of Ms. DB case number 5/2025. Scanned copies of the records, trial court records of. Meanwhile, the proceedings of Ms. DB case number 5/2025 is stayed till the next date. This is the matter on 21st of January.
And my
Issue
lord,
notice to the respondent returnable on 21st of January.
deep knowledge. May I please, your lordship?
Lordship, here the petitioner has filed a title suit for a decree, petitioner has filed for a decree for declaring the suit court as the common fault between the plaintiff and the defendant. Lordship. Here, the title suit was dismissed, Lordship. Title suit was dismissed and appeal was referred and appeal was returned back, Lordship, remanded back, Lordship. On 2 points, Lordship, to determine 2 points, Lordship. Page number 57, Lordship. There are 21, Lordship. Learned Court will exercise jurisdiction under 26 Rule 9 CPC by appointing a survey commissioner for local inspection of the suit court, Lordship. Whether a part of it falls in defendant purchase land. And then the second point is the Lordship, whether the six closest part who is fine mentioned in both Exhibit 1 and Exhibit 2 connects to the municipal road of the purchase land of plaintiff, if as well with plaintiff, Lordship. Lordship, then Lordship, survey commissioner report was submitted, Lordship. After submitting, Lordship, the survey commissioner report is at page number 50.
Page number?
Page number, Lordship, page number, Lordship, is 62, Lordship. Annex 5, Lordship.
Okay. Yes.
Although this report was presented, Lordship, to Junior Division Civil Judge, Lordship, this was disputed by both the parties, Lordship. That is, cross-examination part is at page number 65 and Annex 6, Lordship.
Okay.
Lordship, I have seen my survey report, which I have submitted to this court on this month, 21/6/2024. Even though in the notice of this court, I was directed to survey, demarcate and inspection and measurement of the land of the purchased land, and both the sale deed, the defendant and plaintiff sale deeds were also mentioned, Lordship, but it was not done accordingly. My survey report nowhere mentions that I have complied as per the notice issued by IDS court for survey. It is not a fact as to the report was not pursuant of the direction of the court. Therefore, my report was not legally acceptable. Yeah, this was also disputed by the defendant. And the defendant, then the circle officer neither measured the land of the plaintiff nor the defendant.
Circle officer or Amin commissioner? Who was the commissioner?
Survey circle officer was appointed as survey commissioner.
Circle officer, okay.
Circle officer. Then this
Let's see the, just once more, I have forgotten. Who was the, okay. Page, which page? That you just said, page 57, okay.
Page 57, okay.
Where is it mentioned that the circle officer was appointed?
Okay, survey commissioner.
Amin commissioner also can be appointed.
Lordship, here, Lordship, page 59, the court has asked to demarcate, Lordship.
Page 59, no?
59, Lordship,
Okay,
Annex
okay,
4,
okay.
Lordship. Where it is deemed requisite for the purpose of this suit that a commission for survey, demarcation, inspection and measurement should be issued. You are hereby appointed commissioner for the purpose of survey. and
Okay, yes,
demarcation.
yes. Okay, both the parties have disputed.
Disputed, Lordship.
Then?
Then, Lordship, the court on trial court on 22/7/2025, Lordship, that is Annexure 7, page 67, Lordship. Although it did not accept the first report, Lordship, page 70, Lordship, Lordship, page 67, Lordship, the last part, Lordship. Appointing a survey commissioner for the local inspection of the suit court for determining the following 2 points. Whether a part of the suit court falls in the defendant purchased land. This was accepted, Lordship. In spite of the defective survey report, Lordship, this was accepted. And the second point, Lordship, page 70 will reveal it, Lordship. Page 69, Lordship. From the, Lordship,
অলপ সোনকালে না উঠি দিম
page 69 will reveal, Lordship. From the above review, it is found that the answer of to point number 1 has been answered satisfactorily. The survey commissioner has categorically stated in the report that a part of the shoot put indicate as car measuring tools has fall under defendant's purchase language.
yes yes okay now you agree by this order
This order. Because
and this is final order
not final, it is taken as final order since it is said that I have accepted this report, point number 1. Now point number 2, again, it has been given to determine the point number 2. Lordship, independently, if it is done, then my case does not lie, or the suit board will, disputed suit lane will go somewhere else. Then independently, if it is determined, Lordship, I will not be able to, if I win also the case, Lordship, I will not be able to execute. Execution procedure will not be there, Lordship. So it should be determined, both should be determined at a single time, Lordship.
there was a judgment by the appellate court
Yes, Lordship. It was reverted back, Lordship. On the basis of this, these points are determined. Both were neighbors, Lordship, purchased from the same seller.
that point number 1 you are agreed by the point number 1 or by the point
Lordship,
number 2
the accepting of the point number 1 or the survey report, I am agreed by that, Lordship. As a whole, because the report, Lordship, the report is at Annexure 5, Lordship, it clearly says that it is not done according to the court's order, Lordship. Lordship, now if point number 1 is accepted on a defective report, Lordship, then my whole case goes, Lordship. Lordship, the survey report is at page 62, Lordship.
The points are whether a part of suit land falls in defendant purchase land. And it has been answered in the cross logic that the defendant land was cross injunction, that defendant laws was never demarcated, not demarcated.
Now this case is pending at which stage?
Yes, Lordship, Commissioner's report, Lordship. Again, the Commissioner's report and notice has been issued for Commissioner's report.
We'll have to hear it. We'll issue notice. We'll have to hear it. Okay.
Till then, maybe state, Lordship. Stay.
We will give you one date because it's at the stage of commissioner's notice.
Yes, Lord.
So if there is any urgency, we will order stay. Now I don't think there is any requirement of stay. Let the commissioner's notice come. We'll hear it and I'll bring it on record that next day will be fixed for consideration of stay order. Stay. Learned Counsel Mr. S.J. Soma is present for the petitioner, Sri Pankaj Kumar Kodda. First up, petitioner to take steps to issue notice to the respondent. First up, the petitioner is agreed by the impugned order dated 22/7/2025 passed in TS number 1 of 2017, accepting only a part of the considered survey commissioner's report. So it is submitted that the survey commissioner's report was not according to the order passed for survey, and if the court accepts the report of the survey commissioner in part and directs the survey commissioner to resurvey on the questions already sent for, questions already taken up for survey, the petitioner will be highly prejudiced, full stop. Issue notice to the respondent returnable on dated 8 January, full stop. This case is pending at the stage of report of the report of the resurveyed. Case is pending at the stage of submission of resurveyed report, YED, resurveyed report. So, call for the scanned copies of the trial court records. The petitioner's prayer for interim stay will be considered on receipt of scanned copies of trial court records.
May I please Now, this is an application for my lord, prepare for restoration of my criminal petition. Of course, my lord, there was some misunderstanding.
Application for?
Application for restoration.
Okay.
By recalling the dismissal
My lord,
order.
before my senior starts, my lord, this case has been allotted to Mr. B. Sharma. He has some bereavement
Okay. All right.
in Burma Dubai.
Learned Counsel, Mr. D. Gogoi, Standing Counsel,
Yes,
Forest.
right.
Mr. D. Gogoi has submitted that this case has been allotted to Mr. B.
Sharma, Bankim Sharma.
B. Sharma, who is in bereavement.
Bereavement.
Okay. First of Learned Counsel, Mr. A. Pukasto, A.K. Pukasto, no? A.K. Pukasto is present for the petitioner. List the matter after vacation. Or we'll fix a date.
Yes, madam, fix it.
List the matter on 8 January.
Yes.
Oh, let's move.
Item 12.
May it please your lordship.
Hmm.
This present appeal has been filed under section 23 of the Railway Claims Tribunal Act. The matter pertains to the illegal imposition of penal damage charges, and it's to challenge the impugned judgment passed by the Railway Claims Tribunal.
We'll call for the records.
Yes.
Judgment has already been passed.
Lordship.
We'll call for the record.
Lordship may admit the appeal.
We'll
Similar
admit
matters.
it, yes. Learned Counsel, Mr.
A. Deb on
A-
behalf of D. Rathi.
A. Dev is present on behalf of Learned Counsel, Mr. D. Rathi. Learned Standing Counsel, no? Really?
CGC.
Learned CGC is present for
All that, both the
for
respondents.
the respondents, full stop. Appeal is admitted. Call for the records from the tribe, or call for the records from the tribunal. call for a record of লিখিলে ভাল হ'ব নেকি? What is the case number?
This is OA, it's there in the cost title, synopsis also.
MFA 79.
Call for the records of OA within bracket 3 stroke GH stroke 33 stroke 2023 from the tribunal. Full stop. It was high over day. Old soul to liquid. List after
4 weeks.
List after 4 weeks. Yes. that will
Your
be better.
lordship, similar order may pass on item 14, 15, 27 and 28.
You are there? It একে order pass করে দিবা 14 15
27 and 28.
14 and 15
And
OA is different.
okay
Or yes, or is
order কি বেলেগ তুমি চাই দিবা case number কি
in supplementary list 27 and 28.
I'll admit it all the order abhi sama ase bil di diba ha MFA railway na etu 27 or 28 ঠিক আছে 29 also no
No,
29 is something different
obligate.
Item number 16
Right, enhancement of the compensation, my lord, accident case.
Okay.
My lord, only my lord, death case, my lord. Salary part was my lord, 34,000 something, my lord, but.
will issue notice will admit and issue
Yes, my
notice.
lord.
Learned counsel Mr.
H does.
H. Das is present for the appellant. First of steps to be taken to issue notice to the respondents. The appellant is aggrieved by the quantum of compensation awarded as per order dated 22
11.
22/11/2020 in MSC case number 407 of 2021. Call for the records. Call for the aforementioned records from the tribunal. Call for the aforementioned original records from the tribunal. List. Date na lage date. Issue notice after 4 weeks. Oh, list after 4 weeks.
Yes,
Issue notice to the respondents likila niki. Returnable on 4 weeks. 26.
Lordship matter may be taken up for some time, Mr.
Okay. 29. So 29 ulai gole matra ase.
Earlier, award dated 9/9, it will be 9/9 to 25. That's the
29, no?
award dated. Earlier case.
Oh, 99, okay.
Yes.
Earlier, what is the case number?
My lord, the MSC case number 407/2021.
Oh,
And award dated, my lord, 9/9/25.
oh, 9925. তুমি হেৰি MSC case number চাই লবা হা ঠিকে আছে না এইটো কেপি মহেশ্বৰী নাই দেখোন আহিছিলে ন আছিল এইটো হা
After 4 weeks, Malone post 29. তেখেতে 16 কৰিব মোৰ 29
he was here Sunday he disappeared this is not railway no same railway
Malone
Admitted.
issue notice Malone admitted
same order
same order by kindly
judgment
that's me
খালি নামটো চেঞ্জ কৰি দিবা দেই ইয়াত আগৰ নিচিনা আছিল কেপি মহেশ্বৰী আছে এইফালে
কে গগৈ
CGC
CGC
কে গগৈ লিখি দিলে হৈ যাব আৰু
Malone just like pay for reflecting the name in my cost list also Malone
এইটো লিখি দিবা the name of learned CGC Mr. K. Gogoi is to be raised to reflect the name of K. Gogoi name of CGC C. K. Gogoi in the cause list.
lost it
Big item 26.
Wait, please hold on. My lord, the case is like this, that
নাই কৰা নেকি 29 to records call কৰিলি
The Gurudwara,
Mm.
Dhubri, my lord.
Mm.
That is a very sacred shrine for the Sikh
know.
devotees, my lord. Because there, my lord, the first Guru,
Yes,
Guru
yes.
Nanak Ji, he himself visited that
Mm.
place. And after that, my lord, the 9th Guru, my lord,
Mm.
he came and established this Guru Tegh Bahadur Sahib Ji. My lord. So, all the Gurudwaras, my lord, they have their own Prabandha committees, my lord. So, these Prabandha committees, my lord, they nominate members. And these members, instead, my lord, they constitute the Sikh Pratinidhi Board. So there is a Sikh Pratinidhi Board for the entire Eastern Zone, which controls all the religious affairs of the
Okay.
Sikh devotees. Now, what has happened is that these members who are nominated by the Gurudwara Prabandha committees, they select the president,
Mm.
the secretary, and treasurer of the Sikh Pratinidhi Board. Now, in the and the Sikh Pratinidhi Board also in its first general meeting constitutes an executive committee to run the day-to-day affairs, all the religious functions and everything. So the executive committee will run, and the tenure of the Pratinidhi Board is for fixed period of 3 years, and the executive committee also has a fixed tenure of 3 years, and the president secretary of the board is the de facto member, president secretary of the executive committee. So what happened in this case is that on 9/3/2024, the elections are held in the general board of the Sikh Pratinidhi Board, and the defendant number 1 was selected as the president,
Mm.
and pro forma defendant number 1 was selected as the secretary, and similarly the executive committee was also formed.
Okay.
Thereafter, my lord, on 18/8/24,
Mm.
a meeting of the executive committee was scheduled.
Mm.
But before that, one relative of the pro forma defendant, that is the Secretary General of the board, she died. So all the members requested the main defendant number 1 to postpone the meeting on a different date, that is 25/8/2024. But the main defendant, that is the president of the board, he did not pay any heed to the request, and he went ahead. And also, not only he held the meeting on 18/8/2024, but also he dissolved the original executive committee, which was constituted in the first general meeting, madam, of the board.
Okay.
And he forms a different committee, executive committee. Thereafter, madam, on 25/8/2024, all the members of all the Prabandha committees, madam, they come to the head office, which is at Gurudwara Tegh Bahadur Sahib. And they immediately, Lordship will kindly come to page number 21. They take a resolution in the urgent meeting, my lord. And the defendant number 1, who was the president, he was expelled. He was expelled for a period of 6 years. And his followers, some of the followers were suspended for a few months. And what they did was that they took a resolution that the original executive committee, which was constituted as per the actual original board meeting, my lord, they said that this committee will again run, and it will be headed by the plaintiff, who was selected as the interim president.
Okay.
Now, what has happened is that after that, they requested that the defendant number 1 to hand over all the affairs of the offices to the interim committee, but he did not pay any heed. So thereafter, they filed a suit. Original suit was filed in the year 2024, but because of some lack of jurisdiction, that was withdrawn, and subsequently this suit was filed
Before the district judge.
before a district judge for declaration that this executive committee is illegal.
And that was not decided in favor.
No,
That was
that is the
dismissed.
suit.
Oh.
They are in the suit, and also a miscase was filed seeking ad interim injunction for restraining the activities of the defendant number 1, who still is trying to run the executive committee. Now, what has happened is that there are 2 parallel committees, one formed by the actual board, and the other one which was illegally established on 18/8, the meeting.
So that injunction was also dismissed.
That ex parte ad interim injunction was rejected. Against that, we have come, my lord. Now the thing is that, my lord, the suit is fixed for appearance of the parties on 9th of January. So till then, my lord, if that person is arrested till the appearance of the parties, opposite parties, that is on 9th, till then, my lord, if he is restrained, because, my lord, what has happened is that, my lord, since the executive committee is running the day-to-day affairs, all the accounts and finance funds are being utilized by that person, and a person who has illegally constituted a committee, that my lord, there are very chances of these funds being misappropriated, my lord. Because my lord, all the religious functions, gatherings, maintenance,
Go through the order then.
yes,
We'll go through the order,
That- that-
injunction order,
yes.
rejection
That-
order.
That is at page number 57. That is starts from page number 60. And the relevant para is, my lord, at page number 64,
No, we'll go to the entire order.
my lord.
You're asking for stay, we'll go to the entire.
My
order.
lord. Basically, lords will examine whether there are irreparable loss. Prima facie case we have made out, my lord.
Hmm.
Because we represent the actual original executive committee regarding irreparable loss and balance of convenience. Lords may examine that.
Please read order.
May I read?
I'll read them, you sit down, I'll read
Right.
it. Okay, I'll come back at 2. Anything else? I'll come back at 2. I have some work,
My lord.
then I'll come back and read. I'll come back at 2. If you want some early relief, then I can, because this will take some time, I think
Lordship.
10 pages order.
Item number 18, 19 and 20.
Hmm.
There was interim order
Hmm.
that may continue
It
and,
will get 20, but
and
the other side, the other side. is not
other side is
confirmed.
there.
We have to respond.
Okay.
So-
19 and 20.
20, and we can await for process server report upon 2 and 3.
Learned Counsel Mr. D. Mondal is present for the petitioner, and Learned Counsel Miss S. Roy.
D. Hazarika on behalf of S. Roy.
Learned Counsel Miss D. Hazarika on behalf of Learned Counsel Miss S. Roy is present for respondent number 1. Full stop. Service report on respondent.
2 and 3 may be awaited.
2 and 3 is awaited.
Interim order is there.
Interim order shall remain in force till 21st of January. We have called for any records.
In this case, perhaps record is not required.
Okay.
Oblige you.
But item 17,
Hmm.
though it is the second appeal, my lord,
Hmm.
it is a concurrent. And one page I will show that it may be admitted and
No, no, no.
no,
No, we'll
There-
have to hear it out.
no, there is an inherent defect in this case.
No, then we'll hear it. We'll hear it after 2. We'll hear it.
Here in what happened, suit was dismissed for default and counterclaim was proceeded. Then against that, the plaintiff did not file any application under order and for restoration. Trial court proceeded the case. My counterclaim was also dismissed. Then, after dismissal of my counterclaim, plaintiff preferred appeal without setting aside the earlier dismissal order. Appellate court what has done, decreed the suit, and we have not preferred any appeal against counterclaim.
Okay. Then we'll hear you. We'll hear you. Can you wait till 2?
Yes,
After two.
here in this,
After 2.
it will take only 2 minutes, my lord.
Yes, after 2.
Yes.
Lordship, regarding item number 21, Lordship. Lordship, actually, we have to take steps upon respondent number 9 and 10. We are ready with the steps. And regarding service of copies upon the other respondent, we are ready with that also.
Etu kuntu after 2 will go to 17. Oh. Item number 21, Learned Counsel.
May it
Mr.
please your lordship, before your lordship passes an order, may I submit your lordship? In this case, I am appearing on behalf of the respondents, your lordship. There are 1 to 8. Respondent number 1 to 8, we
Yeah,
are the claimants, your lordship. Yes, your lordship. We have already entered appearance. We have already entered appearance, your lordship. My only respectful prayer is that a direction while admitting this appeal, this honorable court has directed the insurance company to deposit 50% of the amount. Now, being the claimants, your lordship, we are praying that that may be allowed to us. That 50% we may be allowed to withdraw that amount, your lordship. And then we directed to deposit it because there was a clear direction of
Then
depositing
we'll
that.
hear you out. We'll pass an order after hearing.
Yes, your
Huh?
lordship.
Lordship, they may find a separate IF for that, or if they want withdrawal. And regarding the deposit, we have to take instruction, Lordship. That is the issue.
There was a direction whether he is the counsel, your lordship, he should be aware as to whether they have deposited the amount or not.
Instruction is the insurance company, lots of MSA appeals are there, Lordship.
Shall I pass an order or shall I fix a date?
Your Lordship may fix a date immediately after the vacation, Your Lordship, winter vacation, and then until then he will take.
also take the steps today, upon as per number 9 and 10.
No, no, no. Shall I pass if you want me to pass an order, then we'll come back after
Because
two.
we are ready with the steps. We can take the steps. We are just waiting for your lordship's order.
Okay, we'll come back after two then. Okay,
With respect to the claim, Your Lordship, that is why I am praying.
we'll hear you after two then. Okay,
Lordship may fix another date because I have some difficulty.
we'll hear you. You have difficulties.
I am ready, Your Lordship.
We'll hear after two.
Yes, Your Lordship.
Lordship may fix a date, Lordship, because at 2 it will be difficult for me to do.
Okay then. One
That is
day.
why I am praying, Your Lordship. My respectful submission.
No,
is that-
not now, not now. I also am asking for some.
No, no, I understand, Your Lordship. I am praying that the matter will fix after
I-
the vacation.
After
After vacation, I am praying, Your Lordship.
vacation.
After vacation.
Take it to them.
And Your Lordship, they have not served a copy to us.
I will sign it. I'm ready with the copy.
20 and 21, no?
Photo देने के नाम नहीं
21. Learned Counsel, Mr. SP
not
Sharma is
use it.
present for the insurance company. Insurance company, no?
Insurance company.
Mr. SP Sharma, no?
Yes.
Present and Learned Counsel, Mr. T. Devi is present for respondent number 1 to 8. Post up, it is submitted by the Learned Counsel for the insurance company that they will take steps, huh?
Upon as per number 9 and 10.
They will take steps to issue notice to respondent number 9 and 10.
10. Both ways.
As per usual process and as
a speed post.
and through speed posts. Post of Learned Counsel, Mr. T. Devi has submitted that they have not received copies, post of copies to be furnished to the respondents
During the course of the day.
by the insurance company during the course of the day. List this matter on 8 January.
Deeply obliged. And Your Lordship, may I pray, Your Lordship, a direction may be issued to the respondent authorities to verify as to whether they have deposited the amount being as the appeal is.
The Learned Counsel, Mr. SP Sharma, is to obtain instructions if the amount as ordered by everybody is in holiday mood. You all are working. Why you are in working mood?
Item number 20.
Everybody is in holiday mode. You all are in working mode. Why? Huh? Professional है जान. Yeah. Appeal is partly allowed. Amount is enhanced. No. Partly allowed है होगा ना? Amount enhanced कोई ले? Partly allowed है होगा ना? This poster.
Item number 26.
So, my lord, what I was submitting is that this executive committee, which was constituted illegally by the president himself, without any confirmation from the.
Oh, no, no, no. We will read the
Yes,
Miss J
yes.
order.
It starts from page number 60.
You can start from paragraph 32.
My lord.
You can start from paragraph 2.
Paragraph 2. May I read, ma'am? As per the plaintiff, the Sikh Pratinidhi Board Eastern Zone, Dhubri Sahib Assam, which is hereinafter called, the board is a registered society under the Society Registration Act 1860 wide registration number RS 101 of 1980-81, having its registered and main office at Gurudwara Sri Guru Tegh Bahadur Sahib Ji, Dhubri Sahib, in accordance with the provisions of the Constitution and bylaws of the board. A general meeting of GPCs was held on 9/3/2024 for constitution of the board under the supervision of the
You
district.
can read it. You sit down. I'll.
My lord, my lord.
So what type of irreparable loss you are suggesting?
My lord, irreparable loss is regarding, my lord, the utilization of funds.
Funds.
All the,
Where in this petition you have mentioned?
it is mentioned in the main petition, my lord. It
Yes, in the main petition.
main petition,
Yes.
the
here-
injunction petition.
Huh?
Yes. At page number, my lord, it starts from
No. Here in this petition.
in this petition. But this petition is just, my lord, as a continuity of the earlier miscase, my lord. Miscase pleadings will still be there, my lord.
Have you mentioned anything about funds in this petition?
This
Utilization of yes, CRP in this CRP? If you want to stay,
No, basically we are challenging the order which was passed in the miscase, my lord.
yeah.
Miscase, we have shown everything. If your lordship will see,
Hmm.
the signatory in the bank account
No,
are
no.
president and the general secretary.
Here in this case,
Yes, no, I'm coming.
I'm not asking about the miscase. Here also you'll have to give the grounds. I must also find some irreparable loss. Balance or convenience. I cannot find any. At least at this juncture, I cannot find any.
No, but lordship will see the validity.
One committee is functioning. Where is the problem?
Yes,
Let them
but
function.
if an illegally constituted
Status of
committee.
it is decided.
If your lordship will kindly see the resolution at page number 21.
No,
The resol-
go there. Where in this petition you have?
But this petition
What is
chal-
your ground?
but this petition is challenging the order.
Hmm.
Order was passed.
No, the order is correctly passed.
That's what I want to show, my lord. In the
Hmm.
miscase, lordship will kindly see the miscase.
Why I'll go to the petition? I'll not go to the.
Because, my
petition.
lord, the order will have to be.
Here,
passed.
here you have to criticize that that ground was not taken into consideration. You'll have to criticize.
But lordship will kindly see, because the pleadings are already on record. The pleadings in the
No, no.
miscase are
No, no,
already
no.
on
Here
record.
also
We
you
cannot
have to-
take. we
You'll
cannot-
have to give me grounds here also.
But we cannot take new grounds, my lord. The grounds which were
Then-
already taken
then-
are already
then-
there.
No.
No, are already there. Now, whether, my lord, those
No,
grounds
no,
were taken into
No, I don't
consideration.
I don't see any irreparable loss.
My lord, an illegally constituted committee, even if it runs for a single day, now by virtue of an order of a court, it has been made that this illegally
You have
constituted.
not mentioned here that funds are being misutilized.
My lord, it's in the main suit. Main
Where-
suit,
Why should I go to the main suit?
because it's the
Alright,
part
let
of
me
the
see,
main suit.
let me see. Where have you mentioned? In the, not in the main suit. Come on, you must show me in the
My lord,
injunction
main suit
petition.
is the foundation of a civil suit.
No, you must show me the injunction petition. No, I'll not go to the main suit. At least in the injunction petition, you show me that the funds are being misutilized. In the
Lordship will
main
kindly
suit,
see
you are
page
not
number
asking for-
55.
55. In the main suit, you are not asking for injunction.
Yes.
You are asking the committee to be dissolved.
Yes,
Yeah, page
55.
55, where?
page number 8, para number 8.
This is the injunction petition.
Yes. Last part, my lord, the opposite party number 1 has also again changed the signatory of the.
Wait, from where, which page this petition starts?
It starts from page number 43.
Okay. Page 8.
Page 55, para 8.
Okay, please read.
Yes, that the news spread like wildfire and the entire members of the board were furious and offended by the conduct of the opposite party number 1. An urgent meeting of the board was called under Article 18.1 of the Constitution by the pro forma opposite party number 1 on 25th August 2024 to discuss the unconstitutional move made by the opposite party number 1. The meeting on the 25th of August 2024 was attended by 132 members of the board, and a resolution was taken unanimously to expel the opposite party number 1 for 6 years and 9 and 14 till 31 December 2024 from the board as per Article 23.11 of the Constitution. Further, the opposite party number 1 was debarred from doing any kind of activities for and on behalf of the board. The opposite party number 1 was also restrained from representing the Dhubri Sahib anymore in any forum. It was decided in the meeting that an interim president will run the board till the election of a full-fledged president and subsequently vice president C. Bhagal Singh was made as the interim president. The unanimous decision of the board members did not go well with the expel opposite party number 1, and he has been trying to destabilize the board with his political influence and administrative connections. The OP number 1 has also again changed the signatory of the bank account maintained with the Punjab National Bank Dhubri branch in his name with his political and administrative influence, despite the legal advice of the bank suggested to operate the savings account as per Article 28 of the Constitution and bylaws of Dhubri Sahib. It is also important to mention that the pro forma opposite so and so has taken Amrit and is now so
Where is it? Funds are being misutilized.
that is, my lord, the thing is that
No.
bank account will have to be run by the joint sign of the my lord
We
president and
cannot keep
secretary.
guessing. We'll issue notice.
No.
No interim order.
Then lordship will fix it just after vacation. I'll file
Okay.
additional affidavit.
Learned Counsel Mr. S. Doctor is present for the appellant. Issue notice to the respondent.
No, my lord, we'll keep it for motion, my lord. I'll satisfy. I'll file additional affidavit on 6, my lord.
Without notice.
Without only for motion, my lord.
Okay, Learned Counsel Mr. S. Das has prayed for adjournment. List this matter on 6
Yes.
or 7.
6.
For the. You take this back.
My lord.
Item 17.
But it is a reversal of the
Hmm?
judgment of reversal. my lord.
Reversal judgment, yes.
Kindly see, my lord.
What was your point? Tell me.
Point, I want to show that page 34, kindly see.
Hmm.
Entire note sheet of the trial court I have in it.
Hmm.
Page 34,
Hmm.
date 8/11/17.
Hmm.
Defendant side is represent seen the petition filed by advocate for the plaintiff praying for time on the ground mentioned in the petition. Petition is rejected as last chance of PW was already given. Accordingly, this suit is dismissed for non-prosecution by the plaintiff and counterclaim to proceed. I am the counterclaimant.
Okay. So this suit is dismissed for non-prosecution and counterclaim to proceed.
Proceed.
You are the counterclaimant.
I am the counterclaimant.
Okay. You are
Now-
the defendant and counterclaimant.
Defendant counterclaimant.
Okay.
Now, trial court dismiss this counterclaim also.
Hmm. How?
No, my counterclaim dismissed
Okay.
after taking evidence.
Hmm.
After considering evidence,
Final order was passed.
final judgment
Ah.
at page page 91, page 92.
So both
start.
the cases are dismissed.
Dismissed.
Okay.
Nothing survived.
You also don't have a case. Plaintiff also
I
doesn't
have
have a case.
I have not filed any appeal
Hmm.
against counterclaim.
Hmm.
Rather, they have filed an appeal,
Hmm.
not against this order.
Hmm.
They have filed appeal against the dismissal of my counterclaim. And the learned court will, Lord Appellate Court, without considering the records,
Hmm.
decreed the suit of the plaintiff by reversing the judgment.
Okay. Where is the substantial question of law?
Actually, trial court as well as the Lord Appellate Court did not gone to the records of the case and pass the judgment.
Maybe record was very voluminous, maybe.
No,
From
I have
2017.
I have annexed all the order sheet. Substantial question of law, my lord, page 4. I have proposed substantial question of law. Whether the learned Lord Appellate Court erred in law without considering the provision of Order 9, Rule 8 and 9 of the Code of Civil Procedure in declaring the suit of the plaintiff.
Just a minute. Substantial question of
Page 4.
page.
4 of memo of it.
Order 9.
Order 9, Rule 8 and 9. 8 is dismissed for default, 9 is for restoration. Without restoring, can appellate court can enter into the merits of the case.
Correct. Then the other one.
Then other next page, whether the learned Lord Appellate Court erred in law in declaring the suit of the plaintiff in appellate stage without considering the record and order of the learned trial court.
Yeah, we can take this up also. Another one.
Another D part is almost same.
Hmm.
A and B, my lord.
Okay.
A and B.
लिखिए दिया, heard learned counsel Mr. S.K. Ghosh, no?
SK.
S.K. Ghosh for the appellant. Full stop, appeal is admitted on the following substantial questions of law. A or B, page 4 of the,
4 and
Page
5.
four. Page 4 and 5 of the appeal. A and B are 1 or 2 लिखिए दिया. Anything else? Issue notice to the respondents, call for the original records of the trial court as well as the appellate court. Is the matter after 4 weeks? Issue notice लिख ला ना?
I have filed.
Extra copies. I will take up later.
No, because there is a decree.
Hmm.
Plaintiff, there is a decree against
Okay,
me
decree, okay.
for eviction.
I took लिखी जा सर. Heard learned counsel Mr. S. Ghosh for the applicant. S.K. Ghosh for the applicant who has filed and it, who has filed this appeal, it has to be application. It is application order 41 rule 5 of read with section 151 of the CPC. Full stop. It is submitted that in the original title suit number 18 of 2015, wide order dated when? The appeal was dismissed.
Page 34, 8/11/2017.
8/11/2017, no?
17.
2017, the suit of the plaintiff was dismissed and the counter claim was taken up for disposal, full stop.
Eventually, that was also.
Eventually, the learned trial court dismissed the counter claim. Thereafter, the plaintiffs preferred an appeal against the counter claim and the learned appellate court.
Not counterclaim. They have only says against the judgment and decree.
Oh, preferred appeal against the judgment and decree.
Dated.
Which appears to be basically on the basis of the counterclaim.
Yes.
Full stop. The learned appellate court decreed the suit of the plaintiff even without considering the
Order dated.
Defendant's case and the order dated 18. What is the order dated?
8/11/2017.
8/11/2017. Full stop. It appears that further proceedings of title execution. This is title execution.
My lord, I have not. I am paying for
TA.
TA.
It appears that further that operation of the
Impugned
decree,
judgment.
operation of the impugned judgment and decree of TA number 5 of 2023 may be stayed at least till the next date of listing. Thereby, the operation of TA number 5 of 2023 is stayed until till the next date of listing. That only one only, the other one is already both are dismissed, so
No, other one I am
not
not.
required. I think they will come for vacation of this order. This was COVID.
Yes, it can be this.
No, at a come for issue notice COVID until further order issue notice to respondents.
Yes.
Then they won't have to file another,
Let
if they
them
come for vacation of the order, they won't have to file.
Actually, both the court below have not gone into the records of the case.
Trial court maybe, but appellate court, I don't know how she functioned. Trial court may be at least dismissed, but appellate court, how, I don't know.
How
It's better not to
comment
opine here.